Right, just a brief introduction of Precepts Group. So I'm Jaclyn. I'm a director of Precept Trustee Limited and Precept Corporate Services. So in Precept Group, we have four main pillars, which are the Precept Legacy takes care of will and custody. So we do will writing. We also provide will custody service. So under the trustee, the trust side, so we provide executorship, estate administration, trustee, trusteeship, trust administration, and we also do LPA, and client can appoint us as the LPA only, and we also have we can also set up offshore trust in New Zealand. So under the incorporation, the corporate services portion, we take care of and manage, incorporate, and administer local and overseas companies. So So the other pillar is our academy, which is our courses. So we conduct training and seminars and courses all focus on estate planning area, right? Okay, let's dive into tonight's subject. Okay, tonight's topic, property succession. So my score presentation will be talking about challenges of inheritance planning for properties. And we'll talk about, the use of trust. I'm talking about what type of suitable trust can be used, and the absolute property trust. So what are the common challenges that we have pertaining to property? So in Singapore, we have the private property, we have the HDB, right? So a lot of us owns a HDB flat, right? But HDB has its own sets of ruling, right? So HDB, the common ones would be for a single to own a HDB flat, you have to be 35 and above in order to own a HDB flat, right? So there's a lot of challenges, like you cannot transfer a property, a HDB flat to a trust, right? And then you cannot use a trust to hold a HDB flat. So these are the common challenges that we face, right? So when it comes to these challenges, how can I ensure my family members, example, my youngest child can continue to stay in the flat, right? For joint tenancy house, so how can I control my flat is to be distributed? How is it to be distributed after I passed away? Okay, for joint tenancy. So can my beneficiary inherit my HDB flat if they already have one? So can I will my HDB flat to a beneficiary who already have an existing HDB? Can this beneficiary inherit the HDB? Right. So my child is helping out with the mortgage payment. So if my child is helping out with the mortgage payment, how does it affect me from distributing or gifting this HDB flat to other beneficiary, right? What about if I have more than one property, but I have the number of my children are more than the property that I own? Now, how can I ensure that the distributions to my children are fair? Okay, and because properties carries different values, okay, different prices. So how can I do that, right? Okay, next we talk about property inheritance. Okay, what are the challenges? Especially we are subject to HDB rules. So the eligibility of the ownership of acquiring a HDB. So whether you're Singaporean, whether you're PR status, are you owning another flat, or you own a private property? So if that's the case, can you still acquire or inherit, take over a HDB flat? Right? Can acquire a private property after the relevant MOP for Singaporeans only. Okay, so these are some of the rules. So at least 21 years old as a family unit, you can own the HDB flat, okay, in certain circumstances. Okay, that's why there's a bracket of family unit. Or at least you are 35 years old, remain single, you can actually own a HDB flat. Okay, so under the Housing Development Act, right, they have to prevent ineligible person buying a HDB flat through nominees by way of a trust. That's why HDB don't allow HDB flat to be owned under or hold under a trust. So other challenges would be, what about HDB flat for minors? If let's say both parents passed on, that's minor children. So would HDB say, oh, okay, I understand, you know, you have minor children, left behind minor kids, they need a house to stay, right? So therefore the HDB flat can be transferred to the minor to stay, okay, even though they are not of legal age. Do you think HDB will have that kind of arrangement or permit that kind of situation? And the answer is no, okay? Everything has to go case by case basis. So every time when we administer a estate, so we have to appeal with HDB, right? Whether we can allow HDB allow the minors to continue to stay in the flat, right? So sometimes HDB will say that, oh, so you have grandma, grandpa, you have other uncle, aunties, why they cannot house the minor children, right? So I'm not saying that the HDB flat cannot be given to the minor, but you have to sell the HDB flat then, because they are still minor children. They're not able to own the HDB flat. They can inherit the money, but not the flat. So there are a lot of such cases where we have to appeal with HDB, and HDB will review every case, okay? And they will not tell you yes or no by, you know, by just writing in and ask that. There's no standard answer. So every case will have to review by them. Okay. So what if the surviving parent is not a citizen or a PR? You know, there's a lot of foreigners who married a Singaporean, right? Or, you know, what if the Singapore PR passed on, left with the foreigner, right? So the surviving parent is not a citizen and is also not a PR. So what will happen to the HDB flat? Okay, so upon divorce, so if divorce, then what about the minor children? Are they able to continue to stay in the house? Right? So of course, under the law in Singapore, if there's a divorce case, usually the HDB flat will, I mean, the property will have to be settled, right? It's either sell, right? So each party share the proceeds, or one party buy over the other party share. That will depend on how the divorce settlement is being arranged. Okay, so let's talk about some of this common mistake. Okay, adding as joining, then property tax, executor, trustee delay. Okay, too many beneficiaries. What about undue influence? And then, you know, things like that. Okay, so this is one case about joint ownership. So in Singapore, there are two types of ownership. One is joint tenancy. The other one is tenancy in common. Joint tenancy is by default. In Singapore, if you don't mention that, no, I don't want joint tenancy, I want tenancy in common. If you don't mention, okay, by default, it's always joint tenancy. So what does joint tenancy means? Okay, so joint tenancy means that if one owner passed on, the surviving joint owner will inherit the whole entire property, regardless, right? So this apply to HDB flat, apply to private property. Okay, so this case went on to the onto the court, and it was published on the papers. So what happened is that this daughter, she is single, so she bought a landed property. So she was thinking, I'm single, so if I passed on, then the house will goes to who? So without hesitant, she put her mom as a joint owner with her in this landed property. So invited the mom to stay over as well, and also the sister. So, you know, staying together is totally a different thing. It may not be very pleasant and nice. So one day she decided, okay, that's it. I have enough. Okay, I'm going to sell the property, right? I'm going to sell this house. Forget about it. So she told the mom to please move out so that I can sell the house. And it took her so long and so difficult to get the mom out of the house because the mom know that she's a joint owner of the house, right? So finally, she get the sister and the mom out of the house. Then she sold the house. And now the mother wants to bring her to court to claim 50% of the sales proceeds, where the daughter pay 100% of the house. Right. So with a proper planning, she could have written a will and will the house to the mother, to her mother, if she passed on, instead of putting the mother as a joint owner with her. Okay, so there's a lot of in my course of consultation and all that, I've come across couples who say, huh? Oh, so this is how a joint tenancy work. Okay, but I don't want, because I'm the one who paid for all the properties, though it's a joint ownership with my wife. Okay, but I want to decide how I want to manage and distribute my property. But I tell them, sorry, no, it depends on who died first. Who is the last surviving owner? Okay, then that person can decide. If this client is the last surviving owner, right, he can decide how he wants to distribute, right? But if it's not, then he has no control at all. So he will have to, the couple, talk to the wife, whether he can change the ownership, and things like that. Okay, otherwise, there's nothing he can do. Okay, under a tenancy in common, then he will be able to do so. So at least he can will away his 50% or whatever percentage that he owns under a tenancy in common, okay, to whoever that he wants to. Okay, in a joint tenancy ownership, regardless how much I pay, even though I pay 80%, you only pay 20%. But in a joint tenancy circumstances, it's deemed to be I own 50, you own 50. Okay, it's equal regardless, right? So this is the kind of property ownership in Singapore. Whereas Malaysia is different. Malaysia don't have joint tenancy. Malaysia only have tenancy in common. So they don't understand what is joint tenancy. Okay, so these are the property ownership in Singapore, which may cause problem. So if let's say everything is good, relationship is all good, then a joint tenancy may not be a bad thing. But what if a relationship turns sour? Then a joint tenancy can be very challenging. Right. Sorry. Then we talk about this case. This is a estate case that I'm going to share with you. This WLC passed away in 2000, leaving a will. He appointed 2 sons, okay, as the executor. But only 2008, year 2008, the son applied for the grant of probate after 8 years, right? So then the deceased has a 50% ownership in a house. So there is a co-owner, yeah? There's a co-owner. So he is a tenancy in common. So he owns 50%, the deceased owns 50%. In 2016, they decided to sell the house after all the funds runs out, okay, in maintaining the house, right? So the co-owner, but at that time, in that year, the co-owner has already lost mental capacity. No LPA, cannot sign off the papers to sell the house, right? With the other 50% ownership, cannot sign. So then the other family members will have to go and apply a deputyship, okay, with the court to be the deputy in order to sign off the papers for that co-owner. But in the midst of applying the deputyship, because deputyship is a very lengthy, process. Okay, if you have an LPA, it's very straightforward, very fast, immediate, in fact. But if you don't, then the deputyship is actually a very lengthy and expensive process. So in the midst of applying for this deputyship for the co-owner, the co-owner died. Worst. Now you're going to spend more money. So whether a co-owner has a will, don't have a will, you still have to go through the legal process, the probate process, or the administration process, right? So these two sons, being the executor, under constant accusation of mismanagement, okay, by various beneficiaries. They're not the only beneficiary. There are other beneficiaries as well, okay? They're just the two of them, okay, appointed as executor, right? So they will be potentially sued for negligence, okay, by managing the estate. They took so many years to apply for the grant probate, right? So finally, in 2016, under the pressure, they approach Precepts, and of course, being a professional executor, we resolved the co-owner estates, and in 2017, the property was sold. The total duration of this agony for this son X and Y is 16 years. Okay, so you have to be careful who you appoint as the executor, right? Who you appoint as trustee. If they delay the whole process, that's it. No beneficiary don't get anything. If they don't know how to kickstart the process, then the delay is even further, right? So you have to, consider, take that into consideration who you appoint as executor. So this is another piece of case, which there's a huge estate, all right, and then 19 years. Of this 19 years, no money was distributed to the two sisters, right? So basically, there are three brothers who are appointed as the joint executor, okay, for the father's estate, right? So there are businesses, there are properties, and so on and so forth, right? So, but these three brothers never distribute any money out, okay, to the two sisters. In fact, the sister requests for accounts from the brother. Why are you taking so long, right, to do the distribution? So the sister requests for the accounts. So looking at the accounts, they are not satisfied. So they brought the brother to the court. Okay, so the court said, yes, the three of you have not, you're not doing, what are executor duties. You are not discharging your duty properly. Okay, so then the brother, even in the company, right, as an executor, right, vote for themselves to receive high salary, very, very high salary, bonuses, and so on and so forth. So finally, the sister brought the brother to court, and the court requests the brother, right, to return all those money that they have pocketed from the estates, right? So whether are they going to tell the sister, sorry, we already spent off all the money, you got no money to give you already, right? So all those stuff, we do not know. So this case may be dragging on and on, right, for a while before it can be resolved. So this is another case of this doctor. She retired, and she has, unfortunately, she has dementia. She's single, right? So she left with at least a 15 million estate, okay, the assets of because she sold a house, right, for 15.4 million, right? So the maid gang up with the contractor worker, right, and an engineer who works nearby their house, okay, under the construction area, right? So the maid gang out with them, okay, to swindle away a total of 5 million, right, by them from this doctor. So they because she's dementia, right? So they force her, they ask her to sign off a will and will all the assets, right, to them. So when this case was brought up to the court, right, the court looked at the will that she has written in 2007, which contradict very much. In her 2007 will, she written that she wants the bulk of her wealth to be used to set out bursary fund for needy female medical students at NUS. So it's definitely contradict with the latest will that she has written. So she definitely under undue influence and not in sound mind, right, to sign off that will, to write that will, right? So how can we protect beneficiaries who are vulnerable, who don't have the mental capacity, or who are minor, right, not able to fend for themselves, right? So how can we protect beneficiary or family members like that? Okay. So Lisa, another poll. Concerns for your property. So whether it's a HDB that you want your children to stay, until they get their own house, or whether there is dependent adult child who needs a home, or more children than number of properties owned. Do you have that problem? Do you have that issue? Right? And definitely different properties have different value. So how to do a fair distribution? Okay. What about tax? What about, do you have property in overseas that have tax concern? Right? What about in future? Right? Singapore introduced the estate duty again, right? Then that is a tax issue, right? So beneficiary may quarrel if you do a distribution you think is fair, but to them it's not fair, right? So most of you are concerned about different properties at different value. Yes, taxes is a concern. So yes, you want your loved one to have a peaceful stay, okay, during their lifetime. Okay, great. Okay. So we talk about inheritance. What are the principles and techniques, and what are the solutions that we can use? So basically, in a good inheritance plan, right, it includes taking care of beneficiary comprehensively. Okay, instead of giving them a lump sum. So can I plan in such a way where I give them when they need, or I can give them periodically, or I can give them in, when they achieve some milestones, achieve, some conditions that I set in order to receive, right? And I would like to also maintain the control of the assets if I can. And how can I ensure that the trustee that I appoint is trustworthy and have the capability, all right, to manage and administer, right? Is the structure robust enough to endure the changing environment? What about regulation changes? So is my plan able to cater to the changes? So what about tax regime? Okay, changes to tax regime. Changes to individual, executor, trustee, beneficiary conditions. What if the condition changes? What if the mental capacity status? What if, right? They're not there, okay, to act. They don't want to act, right? You know that you appoint someone as an executor and trustee, and this person may agree to do so, and later on, when the will is being executed, right? The person can say, no, I renounce my right to be the executor. I don't want to be. Right. So have you, consider that, right? what about mental capacity? So if I write a will, right, and I return a will, how to do the distribution and all that, yeah, is that good enough? Does it take care of in the event that I'm not sound, or I lost my mental capacity, or I become dementia? Does the will take care? The answer is no. The will take care when I pass on, not when I'm mental incapacitated, not when I'm not sound, right? So then mental capacity will have another instrument, right, to take care of it. Then what about financial situation? What about changes to beneficiary relationships? What if they divorced, right? What if you know, their children, they divorce, but their children are actually, you know, with their mother, okay, in overseas, they're not located in Singapore. So what about that, right? Is there sufficient liquidity, right, that I can provide to my beneficiary, to my family members in the event of needs? So I may leave everything to my family members. I've done a very good planning, but you have to understand that a grant of probate may take 3 months, 6 months, 9 months to complete the process. Then during this period, my family members have any immediate cash to use for their daily expenses, living expenses. So have I, you know, create sufficient or provide sufficient liquidity to them to tie over this period, right? What about clarity of instruction, intention? So have I put a very clear instruction and intention what I want them to do or to manage and to administer my assets, right? So these are the key principles of a good inheritance planning. So of course, there are type of distribution methods. You know, there are the immediate, delay distribution, conditional distribution. So in Singapore, because of the ABSD issue, we cannot freely distribute property to our family members or to our children anyhow we want. So if upon that transfer, is free of taxes, right? It's free of taxes. So there's no ABSD incurred. But that may affect them from buying their next property. Okay, so that is our concern, okay, in terms of the ABSD issue. Okay, so with a good planning, we can avoid you know, avoid transferring the ownership to our beneficiary and free them from buying the property that they desire. And yet I'm able to keep the property, manage them, administer them, or if no one is staying, the property can be rented out. So there are more income that can provide for beneficiary. Okay, so distribution can be immediate, can be delayed distribution, can also be conditional distribution. So in terms of delay and conditional distribution, there is a testamentary trust, which is a trust written in a will. And we can also set up a trust. Okay, while I'm still alive, I set up this trust. So we talk about property life tenancy. So is it good if I have a property, right? But I want my youngest child, or I want this special need child that I have, or these elderly parents, right? Or a brother, okay, to stay for life, but they don't own the property. But when this brother, it is this special need child passes on, then the property is to be given to another beneficiary. So we call this life tenancy. So meaning this beneficiary is able to stay in this house for life until he passes on during his lifetime. But when this beneficiary passes on, then this house will be given to another beneficiary. All right. So the beneficiary can enjoy the assets, but not the ownership. All right. So it can be set up within a testamentary trust or a living trust. So the title deeds remains at the estate or the trustee, right? And not with the beneficiary yet. Okay, so this is what we call a life tenancy. Example, if I pass on, I worry, okay, my husband, right, whether he can continue to stay in the house, or I worried that my daughter-in-law or my son-in-law would chase away, okay, my husband out of the house, right, when I'm no longer around. So I want to make sure that my husband has a roof over his head during his lifetime, right? So I can say that, okay, this house is for him to stay during his lifetime. When he's no longer around, then this house can transfer and distribute to my children equally, right? This is what life tenancy is all about. So in life tenancy, then the beneficiary will not subject to any undue or influence members, because he don't own the property. He don't own at all, right? He only have the right to stay, right? He cannot sell. He cannot will it away, right? So beneficiary is not able to sell the property, right? Even bankrupt, the creditors cannot own, cannot claim the house, right? He cannot gamble away the house. In a divorce, it doesn't fall under the matrimonial assets to be divided out. Okay, so life benefits, then the beneficiary enjoy the stay in the property, or the rental income from the property can be given to another beneficiary, right? And can enjoy, stay, and plus enjoying the income from the properties, but he don't own the properties. So when this beneficiary passes on, this property is meant for another beneficiary, right? So this is life tenancy. So the type of possible living trust structures would be a standby trust, a trust that I set up now, but I can put it on standby mode. I don't need to transfer any assets into the trust, right? Because my concern is, what if I die tomorrow? Okay, so when we do estate planning, right, we have to plan in such a way, what if I die tomorrow and not 10 years later or 20 years later? So if I die tomorrow, what is my concern? Oh, my children are still minor. I have an elderly parent, or I have a special need child, right? Or have a brother who is a gambler, right? My concern is only when I die, but not now. While I'm still living, I can control, I can watch over my assets. Okay, if I want to give money to my children, give money to my parents, give money to my brother, I can do so. I can control it. But if I die tomorrow, okay, the trust will handle all my assets, manage them, administer them, and distribute according to my instruction. Okay, so that is the standby trust, which I set up now. Is a living trust, okay, but it's on standby mode. Whereas another trust is property trust. Is the main asset is property, right? I can talk about this later. So when we talk about standby trust, how the standby trust works is that it's a trust that I set up now, and that I have a will, and my will will mention what assets goes into the trust. Okay, I can say that everything I have goes into the trust. I let my trust control all the distribution. Or I can also mention only certain assets goes into the trust. Example, I can distribute all my cash out, but the property value is pretty huge. So I rather keep the property for some time, right? To let the value, appreciate more, right? Or the property transfer to the trust, goes into a trust. This property is meant for my whole entire family to stay, but nobody owns it. So they have no right to sell the house, and nobody can chase anybody away. Everybody has the right to stay in the house. Okay, So after 5 years of my death anniversary, right, then with all the beneficiary agree, then we can consider to sell the house, right? All the value above this, above 30%, above valuation, okay, I can consider to sell the house. I can set a lot of condition, right? Or I can set this house is not meant to sell, okay? It's going to hold inside the trust as long as possible. So if let's say I set the trust period as for 10 years, 15 years, so the house can only be, we can settle the distribution of the property when the trust period ends. Example, the trustee can discuss with all the beneficiaries. So you want the title of the house, then I will transfer the title, okay, to each of you, all right, equally. Or you prefer to liquidate the property and receive the sales proceeds instead. So it's very flexible in a trust, okay, to have all these different kind of permutations and different, take care of different kind of scenario, right? So I can decide what assets goes to the trust. Okay, so in this case, if I transfer the property into the trust, none of my beneficiary owns the property, so it doesn't affect them for their future purchase of property, right? If they already have the property and they want to, if I transfer this property to them, that means they own 2 counts of property. If they want to purchase another property, that will be the 3rd count already. But if I don't transfer to them, I put it inside the trust, right? If they are currently owning a property, it still remains as 1 count. So it doesn't affect them from buying a second property, right? So that is one benefit, okay, of holding property in trust. And sometimes when you transfer property, distribute property to all your beneficiary, after death, then they usually not as sentimental as you, right? You may be very sentimental over the property, but they may not. They may rather sell away the property and then they go and buy their desired property, okay? But the problem is that property appreciate, okay, over time. So if the property is hold in the trust for a couple of years, then the value will appreciate much better, right? By then, if we sell the property, the beneficiary will receive much more income, much more money from the trust, right? So that is using how we can use trust, okay, a trust to plan, right? Not just the will transfer property to the trust, but it can also take care of when you are dementia. If you are done an LPA, right? The LPA when in the event of dementia or mental incapacity, if I lost my mental capacity, I can also activate the standby trust to take care of my welfare first. Okay, if I have minor children, they are my dependent, right? So the trust can take care of my welfare and at the same time, take care of my dependent of their daily expenses and so on and so forth. So when I become, if I lost my mental capacity, means I don't have the ability to bring bread home for my children, for my family, right? Then the trust will take care of them at the same time, right? So in the event of LPA, mental incapacity, you can also activate the standby trust, right? Not only that, insurance nomination, you can nominate the standby trust. Then for Cpf nomination, you can also nominate the standby trust, right? Because the trust exists, so you can actually nominate under the, Cpf is outside of will. You cannot will your Cpf away. You can only by way of nomination to gift your Cpf money to your beneficiary. But nomination, you can appoint individual, right? Individual, but what if this beneficiary not around, right? So it may be given to the other surviving nominated person. But what if they don't have? Or what if your intention is not to give to the remaining nominated person, but instead you want to give to someone else, right? So why not let the trust, right, hold all the Cpf money, receive all the Cpf money, and let your letter of wishes, your trust instruction, how to distribute them. Okay, so you can consolidate all your assets in one place. Okay, you can nominate your CPF nomination. You can nominate your insurance. You can also assign insurance policy. Just now I mentioned about liquidity, right? How do you create liquidity and ensure that when I pass on, right, my family have the immediate cash to use, right? So our family unit is getting smaller and smaller now. We may not have a lot of siblings to depend on to help me tie through this period for my family. I'm not sure whether they will help or I don't have, then I rather not depend on other people, right? That what I can do is to assign, absolute assign the ownership of one policy to the trust. So when I die, this insurance payout don't have to go through probate or whatsoever. It will come straight to the trust within a very short period. Okay, don't have to go, it bypass the probate, right? Because it doesn't belong to my estate. Actually belongs to the trust already because I've given the ownership to the trust. So the money will go straight into the trust and immediately the trust has the money to take care of my beneficiary immediate needs. That is how you can create liquidity, okay, in this event, in these circumstances. Okay. So advantage of this standby trust, you can control your properties, your assets while you're still alive. You can still buy more properties. You know, you can take loans on property, no problem. You can still control the en bloc sales, whatever, right? You can also appoint a protector in a trust. Now, what is a protector? A protector is someone that is your family members or a family friend, right? Very close to the beneficiary, understand the situation of the beneficiary, right? And watch over how the trustee administer the trust assets. All right, so the protector has the right to question a trustee. Oh, I want to take a look at the accounts, the trust accounts. Okay, have the right to ask, have the right to question. Okay, and also the protector as a bridge between the trustee and the beneficiary. So example, the minor children, they may not know how to come forward to the trustee and say, Uncle Trustee, you know, I'm sick now, I need money, right? But the protector is there. This protector knows the situation of the beneficiary, right? You will come forward and request for the beneficiary, right? This trustee, this beneficiary, you know, needs money for medical, right? So the money don't have to go through the protector hands, right? Whatever bills, whatever invoices that you present it to the trust, the trustee can make payment directly to the institution, right? But any of the distribution consent, we can always discuss with the protector. Example, if beneficiary come forward, say, Uncle Trustee, I want a car, right? So then I will ask the protector if this beneficiary wants a car. So can we give? So protector can advise us and say, yes, because the beneficiary just you know, got a job, is a property agent, right? So he needs a car, you know, to you know, for his work. So then it's reasonable. Or the protector can advise the trustee, say, no, this is the third car, okay, that he wants to own, right? So therefore, it's a luxury, no need, right? No need to consent to this request. So the protector acts as a bridge between the trustee and the beneficiary, because we don't stay with the beneficiary every day. We do not know their situation. Okay, so the trustee has this mandate from the settlor. When the settlor is due, settlor means the person who set up the trust. Okay, so we have this mandate from the settlor, right from the start. When he set up this trust, he already written all his instruction down, how to distribute, how to administer, in what circumstances don't give, what circumstances can give or can even increase, you know, the distribution, and so on and so forth. And this instruction is called the letter of wishes. This letter of wishes can revised again and again, okay, during the settlor lifetime until he is happy. All right, and usually at no cost, unless abuse, you know, you do the changes every month. Otherwise, there is no cost to this revision. So it's good to revise this letter of wishes every like 3 years, 5 years. If situation change, you bought a new property, you sold away, and assets, then you want to readjust, revise your distribution. Example, this son this year very naughty, okay, I cut his percentage, right? Or next year he seems to be behave well already. Maybe I put back the percentage, revise again, right? So these are things that you can decide and you can revise during your lifetime, right? Also give us the instruction on how you want us to administer your assets. Example, you give us instruction on how to invest the money inside the trust. Okay, 30% don't go to high risk. Okay, I can accept medium risk, but only to certain products. Or no investment at all. Just put all my money, okay, in a fixed deposit, collect fixed deposit in fixed interest, or money market that fetch a fixed income. Okay, maybe 2 to 3% kind of return, right? So with this investment income or the interest earned, right, from the trust funds, right, would take care of the beneficiary distributions and even the trustee fee and so on and so forth. So we will not touch the capital. So the capital is preserved, right? So all these liquid assets are able to pool together, like your CPF money, your insurance payout, your investments, right? Your dividends from business, yeah, your cash and everything, you can pool them together, right? So it can take care of the taxes in maintaining the property, and it can also take care of if the property needs to be furnished, renovate, right? Need some some stuff need to be repaired and so on and so forth. So all this are able to take care, okay, of this issue, right? So money can handle changes environment, example, the en bloc issue, right? So once the property is transferred into the trust and the trustee is the owner, legal owner of the property, if any of the en bloc issue, right, then the trustee will be able to handle the en bloc. But of course, if there's a protector appointed, the trustee will discuss with the protector or with the beneficiary. Okay, so it's very affordable to set up a standby trust. It doesn't cost you an arm and a leg, and it's very easy to set up, right? And couple can set up a trust together, right? This standby trust together, because you have common beneficiary, right? No need to set up separate trust. So couple can set up one trust, a joint trust together, a joint settlor trust together, right? And both of you will write down your instruction. Okay, so whatever instruction, whatever revision you want to do to the letter of wishes, both of you has to agree. Okay, if I want to change the percentage to my son, okay, my husband has to agree. Huh? Then if he say that, hey, you too biased to our son, I don't agree, the way you change, then you have to come to a term to agree, okay? Because both of you will have to sign off the letter of wishes, okay? Agree with all the changes, all right? And the husband and wife, right, both will have to write their own will, and they can transfer all the assets into the trust. They can mirror each other. They can say that, okay, I give my husband 100% first, right? Husband also give wife 100%. So if both of us are not around, then the assets will go to the trust, right? So it's only on second death, right? Then the assets will go to the trust. So if my husband is around or I'm around, nothing goes to the trust, right? It's still on standby mode, right? So you can structure it that way. You can also structure everything. I don't care whether he's still around or not, but I want my assets to all go into the trust so that I can ensure that all the money will take care of my children. What if he remarry? If he remarry, then he take my 100%, then he don't transfer to the trust, he remarry, he got children, then how much will my children receive, right? So there are different ways of structuring, okay, your will and your trust, right? So money in the trust would be able to protect against, scammer, fraud, that, the story of Yang Ying, right? The elderly lady. So there's so many Yang Ying and so many scammers around, right? So trust would be able to protect, okay, vulnerable beneficiary like them, right? So, and any spendthrift beneficiary, in the event of any of my children going through a divorce, that I can instruct the trustee not to distribute first, hold back, pause the distribution until their divorce is concluded, right? Because I don't want my distribution to go out and form part of the matrimonial assets to be divided out. What if potentially it fall under, right? So I don't want that to happen. The trustee just stop giving, just pause it first, right? Until the divorce concluded, then the distribution can continue, right? So these are some of the advantage, okay, of having a standby trust. Okay. Now we talk about this hot topics, absolute property trust. So recently you heard about the announcement, right? The IRS announcement on property, the ABSD issue, where they talk about the D5%. So if anybody were to set up a trust, an individual, using the declaration of trust method, right? So the beneficiary must be absolute, right? If there's no absolute beneficiary, right, then you'll definitely be hit by the 35%. So you must pay the 35% ABSD first, then they will review the case. If they think that yes, your trust is proper, you have named a fixed absolute beneficiary, I will refund back your 35%. Right. So based on this, right, we have also written and reflect back to IRS and ask for clearer instruction and clearer guidance, okay, because they mentioned about declaration of trust. So it looks like the declaration of trust instrument is more towards those individuals who appoint themselves, okay, as the trustee, right, for their children. So in Precepts, we have set up quite a few property trusts. We have set up quite several property trusts, but we are the trustee. So there is a proper trustee. The beneficiary is fixed, right? Absolute, is irrevocable. Trust, okay? So there is a vesting period, and there's a proper account. Every property trust has its own bank account. So all the rental income will be recorded and kept in the bank account. So there's a proper account that we generate every year, okay, on a yearly basis. So IRS also audit, okay, all our property trust cases. So they will ask, like, when is this trust formed? How was the property being funded? Okay, when was the money? Okay, the chronological order, in chronological order. So when was it signed? When was the OTP, right? Then when's the next fund, and so on and so forth. So IRS has audited, okay, all our property trust cases, and we passed the audit, okay, because it's proper. So we think that, you know, what IRS announcement is more on those individual who set up, you know, or appoint themselves as the individual trustee for their children. So maybe some of the records are not mixed with their own money, you know, don't have a proper record, and so on and so forth, right? So, but at the moment, we are also not setting up this property trust, okay, until further clearance, okay? We do not want our clients to pay the 35% upfront first, and then wait for them to review and say, oh yeah, your case is you know, that is proper, okay, if it's qualified, right? So I will refund you the 35% now, or sorry, you know, in their view, it's not. Then, you know, in the first place, if I know that I have to pay the 35%, I won't even consider buying this property, right? So we do not want that to happen. So we are waiting for further announcement, okay, from the authority, right? And also in the whole announcement, we have not seen any mention about death transfer, right, from the will transfer, right? So that will incur the ABSD. So we still believe that death transfer is free, all right? So if from will, you will the property to a standby trust, that should not affect. Okay, so but we are still waiting for the authority to clarify, okay, on this and give us a clear guidance on this. Okay, but let me share with you how the absolute property trust works. So of course we have this ABSD, right? So if I want to buy a property, okay, for my child, but because the child is still a minor children, right? So if I buy for this child, I'm afraid that he's not mature enough, right? You know, then, you know, if he sell away the property at the wrong time, you know, or he, you know, somebody come and scam him of the property, you know, put a joint name in the property, you know, things like that. So I'm worried. I want to protect my beneficiary, my child. So how can I protect? So I buy through a trust. I use the trust, I set up a trust and use the trust to purchase this property and name my child as the beneficiary, right? So I give to him. So he's the absolute beneficiary, right? And vested a period, meaning I set the trust period, right? Until he is 25, example. So in this whole setup, I am the settlor, right? I set up the trust, I'm the settlor. I can also appoint, you know, myself or my husband as the protector, right? Also prevent them, you know, at the age of 21, then they want to sell away the property. So then the protector is there to stop this, right? So then the trust is irrevocable. I give this property to my child. I cannot cancel the trust, terminate the trust, and take the property back to myself. I cannot do that, right? So this irrevocable is an absolute gift. Yeah. Okay. So that's why the treatment of the stamp duty is that, you know, once I set up, I have a named beneficiary in the trust, which is my son. So under this son's name, he already own one property, even though the property is held under the trust and he have not reached the age of 25, the property is not going to transfer to him yet. So at the age of 25, right? So he will receive the property, but now he's not owning the property yet, but he already consider he has one count of property. All right. So if he were to buy another property, that will affect the ABSD would definitely come in. Right. So if this property trust structure, in this structure, right, you need to pay the basic stamp duty, which is a 3% or 4%, right? Then in this structure, because I'm giving it to my son, right, it's an absolute gift, right? This whole structure does not have this, doesn't incur ABSD. So we are still, this is what we have done before, okay, for our client, the property trust that we set up. So we are still waiting for a clear guidance from the authority to tell us that what we have done is stands. Okay, it does not incur any ABSD. All right. So so the problem is that when the parents themselves act as a trustee, right? But is there a real trusteeship going on? Do you separate your own account or do you mix your money? Right. This is very important. So as a trustee, you must discharge your duty as a trustee. It's fiduciary in nature as a trustee. Right? So would the parents be able to pass through the IRAS audit of the trusteeship? Okay, so then by appointing a corporate trustee, then you demonstrate that is indeed, okay, I consult and appointed a professional trustee, okay, to hold this property for my son until the vesting period is over. So this is how the property trust works. So I, as a settlor, okay, I appoint a protector, right? I can be appointed as protector. Then the property trust is a fixed, there's a fixed beneficiary, fixed and irrevocable trust. So I cannot terminate the trust and take back the property to my name, right? And meanwhile, when the property is in the trust, I can rent it and collect rental income, right? Whatever rental income collected in the trust is for the benefits of the beneficiary, right? If I sell the property, then the money remains in the trust. If the vesting period is not over yet and I sell the property, right? So then the money goes into the trust, it holds in the trust until the vesting period is over. Then the money belongs to the beneficiary. Whatever it is, the property meant for the beneficiary, whether I sell, whether I rent it out, okay, all this income, all this sales proceed belongs to the beneficiary. But what I can do is that the rent, I can actually disperse, okay, distribute living expenses, education money to my beneficiary, okay, to my beneficiary, okay, in a monthly basis or a yearly basis for education or for living expenses. All right. So if I sell the property before the vesting period, the money goes into the trust, I can reinvest into another property and holding it while waiting for the vesting period to be over, right? Or if I don't, then the sales proceed will stay inside the trust, but meanwhile, I can still do some living expenses distribution to my beneficiary, right? So this is how the property trust works. But no matter what, the property, the income, the rental income, the sales proceed belongs to the beneficiary. Okay? So whatever, all those money, okay, the rental income or the sales proceed or whatever cash that retains kept in the trust bank account, we used to pay for the property maintenance, right? The quarterly management fee and also property tax, right? All this needs to be taken care of, right? And also for fire insurance of the property, right? So these property trusts only apply to, can only hold private property. It cannot hold HDB, right? Because HDB ruling. Okay, so every family situation, of course, there is a trust that can structure to suit the family objective, right? So, standby trust is a very useful trust where I can set up now, I can list down all my instruction, how I want the trustee to take care of my beneficiary. All right, example, I give you some example condition, how I can set in my trust. Example, if I said that when I die, right, all my assets goes to a trust. Okay, every year I have distributions to my children, including my spouse. So when I die, my husband, though pay respect to me every year, come to my grave and pay respect, then that year he don't receive any income. Same goes to my children. Okay, then I can also say that the funds provided in the trust is for my children's education, medical, okay, to take care of their medical, right, their expenses, and also can set aside an entrepreneurial fund. If they decided they are creative enough, they want to set up their own business venture, they can. Okay, I will help. Okay, max to 200,000. Okay, only one time. They're only given one chance. Right, I can set aside an entrepreneur fund. Right, for property, if my children, my family, my beneficiary doesn't want to stay in the property, then the property will be rented out, and rental income will form part of the trust fund, okay, for the benefit of the beneficiary. So the trust, the rental income will always come back to the trust to form part of the trust fund. Then I can end the trust period, when my trust fund depleted or when my youngest is 30 years old, right? Or there are no more beneficiary in the trust, right? Then I can consider to end. Or I can set the trust period as 10 years after my death anniversary. It's flexible, okay, to end the trust period. And you can revise this trust period, okay, over my lifetime, okay, when I'm happy, until I'm happy. Okay, so now I may set my youngest is 30. 3 years down the road, okay, I don't think he's 30 years old, he's not mature enough to receive all the inheritance. I set it 40. I can still revise that. That's how the trust works. So the trust I set up today, right? I can instruct my will what assets goes into the trust. I can pour everything to the trust. I can I can choose certain assets to go into the trust. Not all, but certain. Right? You can structure it, okay, as you please. Right? I can also give it to my husband 100%. If he's not there to receive it, right, then it goes to the trust. So it's flexible for me to do so. So like I said before, property in Singapore, right, unlike other country, we cannot freely give 2 properties to my children, 3 properties to these children, and so on and so forth, because that will affect their, you know, if they want to buy their desired property. So sometimes transferring the property into the trust, right, and the property they want to stay, they stay lah. If they don't want to stay, then the property can be rented out and the rental income still come back to the trust. Or if the property is to be sold, the sales proceed will still come back to the trust until the trust periods end. Right. And I can also set in the event that all my beneficiaries agree, okay, to sell the house, right, then the trustee can do so. I can also set a lot of conditions. If just one beneficiary don't agree, then the property will continue to hold in the trust until the trust period ends. So it's very flexible, okay, to structure, okay, in a trust. So okay, then that is all that I shared today. All right, Lisa, you have something to share with them?
Yes. So finally, we would like to launch this final poll on the consultation. So if you are invited by one of our estate planners, so do reach out to your estate planner regarding today's whatever that you have heard today. If you have any additional inquiries, you can check in with them. But for those of you who are not invited by a particular estate planner that you can reach out to, please do participate in this poll that I've just have it over here on the Zoom session itself, to let us know that you are interested to have 1 hour free consultation, and we'll get one of our estate planners to contact you.
While you are doing the poll, let me answer some of these questions here. Okay, can a overseas property, Malaysia property, be transferred to a private limited upon death? Then the share of the private limited is to be transferred to son upon death. Rationale is that testator doesn't want son to hold property in his name, as it will affect HDB eligibility. Once you own private property, even though it's overseas, it's no longer eligible for HDB. Well, a Malaysia property be transferred to a private limited. So that will also voice down to Malaysia. I'm not sure you mentioned here private limited, or are you talking about Sedang Berhad company? Because Malaysia property, whether that property can own by a foreigner, right? If it's a private limited, means a Singapore company, then, you know, that would depend on the land law in Malaysia, whether that property is able to own by a foreigner, because a Singapore company is a foreigner. If your private limited here refers to a Sedang Berhad, yes, in the will, you can will this Malaysia property to a Sedang Berhad. Okay, and then the Sedang Berhad, right, can transfer to the son to the will, meaning while you're still alive, you transfer that, you use a Sedang Berhad to hold the Malaysia property, and then in your will, you will the Malaysia property share, the Sedang Berhad, the share to your son upon death. If that is the case, I've seen a lot of people do that. Okay, especially Malaysia property or agriculture land, especially in Malaysia, owned under a Sedang Berhad. Okay, that structure, yes, it may workable, but provided that Malaysia property is able to own, okay, by a foreigner, because you may be a Malaysian, a Singapore PR. So because of that status, you are able to hold that Malaysia property, right? Whether you transfer it to a certain berhad to hold or under your name, you are still qualified because you still have the Malaysia status, right? But once you transfer a share to your son, who is not a Malaysian, who is a Singaporean, right? Then Malaysia side is acceptable or not? That is one question that you may have to find out from Malaysia. Okay, next, husband and wife buy a private property with 30% and 70% share. Can they choose joint tenancy agreement, or joint tenancy agreement must be 50-50? Okay, so if you are talking about buying a private property, but where is it? Bought a property 30-70, so I believe this is a tenancy in common arrangement, right? Then you want to change a tenancy in common to a joint tenancy. You serious? Because in a joint tenancy, then it's definitely 50-50 regardless how much you pay. Okay, so why not retain it under the tenancy in common structure where you have more flexibility? You can will away a 30%, can will away a 70%. Right, freely will away, and you can control your 30% share of the property, who you want to distribute to, right? Rather than change it to a joint tenancy, right? A lot of people wants to change from joint tenancy to tenancy in common, and it's not easy. And you want to change from a joint tenancy, a tenancy in common to a joint tenancy.
Okay, last call for those who would like to have a free 1-hour consultation, but do not have a estate planner that invited you here for the talk today. So you can just indicate yes under this poll that we have launched. So for those of you who didn't manage to indicate it accordingly, not to worry, you can always call into our main line or at Precepts or email it to us.
Okay, let me continue to answer the questions. What if all the beneficiary have passed away before selling the property? So what will happen to the property which is under the trust? So if let's say the property is under the trust and all the beneficiary have passes on, and because I suppose the trust period hasn't end, right? Have not end yet. I mean, it's not the end of the trust period, but before the end of the trust period, all the beneficiary passes. The other beneficiary passed away. So what happened to the property? So in your trust, in the letter of wishes, you will mention that if all the beneficiary, okay, has does not survive anymore, okay, no beneficiary. So who is the substitute remaining man? That means the substitute beneficiary to receive the remaining assets in the trust. Okay, so this part you have to close up the gap, right? So if let's say I set my trust period as the trust period will end, okay, if my youngest turn 30, or when the trust fund depleted, or my trust fund depletes to 100,000, okay, 100,000 and below, no point keeping the trust, okay, or all my beneficiary have passed away. So then if all my beneficiary have passed away, then by right the trust should end, right? Then I will have to add on to say if all my beneficiary have passed away, then the remaining asset is to give to who? Give to charity, or give to my niece and nephew, right? Give to who? So if you have stayed down, closed up all this gap, right? So the last remaining man, then even once all the beneficiary have passed away, the trust should end already. So the trust was sell the property, whatever remaining in the trust will be distributed to the substitute beneficiary. Okay, so technically it's like that. Next, after I have passed away, few years later, the protector passed away too. How? Okay, monthly allowance. So usually, of course, we will encourage clients to appoint protector and substitute protector. Okay, so if you have one protector, unfortunately, passes away, no protector, then the trustee will take full discretion based on the letter of wishes how to provide for the minor children, okay, according to the letter of wishes. If your letter of wishes mentioned that there will be monthly allowance, okay, whether the protector is there or not, the monthly allowance will have to be distributed out, okay, provide for the minor children or the special need child or the elderly, okay, according to your letter of wishes. So what happened to the property under trust if the child passed on first? What happened to the property under the trust if the child passed on first? I suppose this question is referring to the property trust. If it's under the property trust structure, right? If the child passes on, is a minor and have not written a will, then it will go under intestate distribution, right? So it will go back to the parents because it's an absolute beneficiary, right? So then it will fall under the beneficiary estate. This is what happened under a property trust. Unlike a standby trust is a discretionary trust. So therefore, I can actually put down who are my substitute beneficiary. If all my named beneficiary pass on, right, then who are my substitute beneficiary? Okay, that is discretionary trust. Okay, discretionary trust, I can also mention in what condition they receive, in what condition they don't receive. But in a property trust, it's an absolute fixed trust. Therefore, if the child passed on, then it will fall under the child estate. Okay, then if the child have not written a will because the child is minor, then it will fall under the intestate distribution. So likely it will go back, it should go back to the parents. Okay, next, in your example, absolute property trust, what if the father wants to sell the property when the son is still a minor? Okay, so of course, the father, being the settlor, can sell the property, but bear in mind, in Singapore, the property, you must hold it for at least minimum 3 years, right? Otherwise, you will have the seller's stamp duty, right? The buyer's stamp duty, right? So then you can sell, but the money goes back to the trust. Okay, the father cannot enter trust and take back all the money and take out all the money, cannot. Okay, because there's a vesting period. And moreover, whatever money belongs to the son can only receive at the age of 21. So that is the Singapore law. Okay, legal age in Singapore is 21 to receive cash, to receive property. Okay, so the father can decide to sell, but the money goes back whole in the trust until the trust period ends. How much is the absolute property trust? Is this a one-time payment or recurring? Yes, that will be recurring because the property will be holding under the trust. So that is trust admin fee, right, will kick in. So if you are interested to know more, you can contact your consultant or whoever that invite you to this session, right? Otherwise, you can contact Lisa, my colleague. Next, for absolute property trust, property tax of the property is charged at owner occupied rate if beneficiary stay in there, or all properties under trust pay property tax. No, it's not charged at owner occupied rate. It's on the higher side. Okay, so of course, the property trust, by way of gifting, the property to my children, right? By, in protecting my child, in holding this property and so on and so forth, I enjoy, right? It happened to be a ABSD saving, but there's no, perfect, okay, on both world, right? So it's not charged at owner occupied rate, right? Even though the beneficiary is staying there. So if let's say the property is rented out, then it will be taxed at 17%, the corporate rate for the rental income generated. I have a property bought under trust for my son. Can I have another trust that over this trust that this property will be under a standing trust? That is a change of trustee. You can do so from a personal. So now I'm a trustee. So I want to change trustee. Okay. So example, I want to change to Precept trustee. So that is a change of trusteeship here. You can do so from a personal to a corporate trustee. Is income of a trust subject to income tax? Or that depends on the nature of the income. So in Singapore, investments, income, bank interest earned are not taxable in Singapore, right? Business, dividends, all these are already taxed at the tax at source, okay, at the corporate level before it flows down to the trust. Rental income, right, has to pay income tax, right? So if the property is held under a trust, it will pay at a corporate rate of 17%. So generally in Singapore, right, most of the income, okay, generated in the trust are not taxable, okay, because dividends, business income, all tax at source already, right? Then it flows down to the trust. And then whatever investment gains that the returns that you make, right, is not taxable, right? But unless, Singapore don't have capital gain tax anyway. So unless you are doing trading, very active trading, you know, day in, day out, then it's deemed to be a trading income. And those trading income will be subject to tax. If it's just our normal buying stocks, you know, for short-term holding, you know, buy some stocks here and there, actually those are not subject to tax. The cost of setting up a standby trust, okay, I'll just briefly tell you. For a single settlor, for a person to set up the trust is 5,000. For a joint settlor, a couple to set up is 6,000. So it's very affordable, right? Very affordable. And we don't require, you don't have to put any assets, transfer any assets into the trust. The standby trust only require an initial trust fund. A trust cannot have no assets. Initial trust fund of $2,000. And that $2,000 is your own money. Right? And then because it's on standby mode, so therefore there is no trust admin fee, okay, kicks in. There's no recurring cost, right, every year. But there is a small disbursement fee of $50. This $50 is to generate a trust account to show you how is your 2,000 doing, okay? Or if you have a assigned insurance policy there, the trust account will also reflect the insurance policy as well. So this one is on a yearly basis to show you, hey, how's your 2,000 doing now? Now the $50 will be deducted from the 2,000 initial trust fund, okay, for many years. So for many years, we will not disturb you until the 2,000 is exhausted. That we may request a top up, right? So the fee is very minimal and it's very affordable. Okay. So can the absolute property trust buy additional properties without incurring? No. Why? Because you have named one beneficiary. So that one beneficiary, remember what I mentioned, even though the vesting period, okay, can be 15 years, 20 years, but that fixed beneficiary already have one count of property, even though he has not received the property yet. It's still on hold in the trust. Okay. If you buy another property in the same property trust, then there's two count. If you're thinking of, hey, I do a separate property trust lah, don't buy it from the same trust, but I set up another trust, okay, but naming the same beneficiary is still two count, right? Because it's fixed beneficiary, right? So that would definitely incur ABSD. Okay, can they mortgage loan? No. So the property trust itself, okay, is an absolute beneficiary, you know, fixed trust, absolute property trust, and so on and so forth. By way of doing this, by way of gifting, okay, that is a saving on the ABSD, right? But it comes with condition. Nothing is free, okay? The requirement is that you cannot, it has to be cash, no financing. So when my son gets my property after I'm gone, does he needs to pay 70% of the market value to get the property? No. For debt transfer, okay, if it's the debt transfer, there is no taxes, okay? There's no transfer cost, there is no stamp duty, there shouldn't be an ABST, which we believe, okay, but we want the IRS to clarify on this and make it very clear, right? But so by right, there is no stamp duties, it's free. So property, if it's under your name now, you better don't transfer to anybody, okay? Because that transfer is free. So don't transfer to a trust. Don't think you set up a trust now and you transfer your existing property to the trust now, okay? If let's say it's a standby trust, okay, you definitely be hit by ABSD, right? That transfer is all free. So whatever that you have already done, okay, hold under your name, then don't do anything, okay? That transfer is free. If let's say I have a property now, I own a property, and the property is already fully funded, that means I already paid, okay, free of encumbrances, okay, no more financing, is fully paid. I can actually set up a property, the absolute property trust, and I transfer this property, or rather, I give this property to my son. I name my son as the beneficiary in this trust, right? Then I have zero count, right? I can buy another property, but this property belongs to my son already. If I do that, okay? So your existing property must be free, okay? No more financing. Then you can gift your existing property to an absolute property trust for a beneficiary. And this beneficiary must have the profile. The profile must be never owned any property before. This you must always remember. That's why a lot of parents use children, okay, as the beneficiary, because they don't own any property at all, right? So then it will free me, right? Now I have no more count already, so I can go and buy another property. So when I buy another property, I can take financing, I can take loan, because it's under my personal name. Okay, right. How much is it to unwind a standby trust? We call this a revoking of a trust lah, huh? Probably about 1,000 to 2,000 max, okay, to revoke a trust, a standby trust. So why do you revoke a standby trust? Right, when you set it up, right? So if let's say I plan, what if I die tomorrow? So if I die tomorrow, I have a young children, I have a elderly parents, okay, that's why I set up a standby trust. And if I leave, and I'll transfer everything from my will, okay, to my standby trust, okay, to provide in the event that untimely death of me. So if let's say I live long enough, my children grow older, my parents pass on already, actually I don't really need to provide so much for them, right? And I don't think I need the standby trust anymore. Okay, then you can choose to revoke it, or you can choose to rewrite your will. Nothing goes to the trust will never be activated. Okay, so that is another way of doing it. Right. If the property is held in the trustee and occupied by one of the beneficiary, is held in the trust and occupied by one of the beneficiary, would that be a deemed income under the trustee and tax? Why? Unless if the beneficiary pay rental? No. If let's say in my letter of wishes, I mentioned that these property, I'm not sure whether you are referring to the absolute property trust or standby trust. Okay, so let me first explain the standby trust, how it works. So if let's say the property is held under a trust, okay, and our beneficiary is staying in the property, okay, which I allows it, okay, in my letter of wishes, I allow, if any of my beneficiary wants to stay in the property, they can stay, so it's free of rent, so there's no rental income received. I can also mention that I will, if any of my beneficiary wants to stay, okay, I have the trustee will have to rent to them, they have to pay a rental, right? Okay, pay a rental. So free rent or with rental. So that's how I can decide this, okay, while I'm drafting the letter of wishes, whether I should let them rent free or not. So if in the event that in an absolute property trust, okay, scenario, so if let's say my beneficiary is staying in the property, right? If there's no rental collected, there is no rental income to be taxed in the first place. Okay, but the property tax is definitely, you know, unavoidable. But if the beneficiary stay rent-free, then there is no income at all. Okay, next, if I buy property which still under financing in my name, it cannot be transferred to a standby trust put in the will. Okay, yeah. Okay, standby trust is a trust where I do not activate during my lifetime. Okay, I only activate upon death. So upon death, if my property is still under financing, okay, then this property is supposed to transfer to the trust, right? Correct? So then my estate, whatever money I have, will have to pay off all these outstanding mortgages first before the property can transfer to the trust, right? So the best planning is that make sure you have a mortgage insurance, right, to cover those outstanding financing. Otherwise, you know, to pay off the liabilities, right, to pay off all this outstanding loan will have to come from your estate. So then your beneficiary will receive less money. So the best is to make sure that you have a mortgage insurance to cover the outstanding loans. Okay, so then it will not affect your estate, the assets in the estate. You will not utilize so-called utilize those assets or use those assets to pay off the outstanding loan. Otherwise, it will affect, you know, the amount that your beneficiary will receive. So before the property can transfer to the trust or to transfer to the beneficiary, right, the loans all have to be settled first. Or in some event, some situation, we can discuss with the beneficiary. So you want to take over entitled? If you want to take over entitled, do you want to take over the outstanding financing? That means you continue to finance the property. So if the beneficiary say yes, I can take over the financing, I can continue, right? Then it will come back, go back to the bank. Okay, the bank will have to review because they may need to do a refinancing. Now the owner is a different owner. Okay, so it all depends on whether the bank is okay, not okay. So the beneficiary can also say, no, I don't want to continue the financing. I don't want to finance it. So please sell it. So then we will have to settle with the bank. So the bank will have to sell and then settle all the outstanding, okay, mortgages, or the financing with the bank. Right, before the bank can release. So that's how it works. So will transfer is always free, okay? From death transfer, I would say. Death transfer of property is always free of taxes. All right, no stamp duty, no transfer cost, nothing. So the death transfer is the best way of distribution. What is the average estimated cost to set up a trust by Precepts and annual fee, if any? So I suppose you are referring to a standby trust, which I mentioned the fee just now. But if it's a absolute property trust, then it depending on several factors like the value of the property, right? The background of the settlor, profile of the beneficiary, right? Because the risk, how should I say, the review, the risk will be different. Okay, if let's say the profile of the settlor, okay, is a US person, or you know, a come from a high tax regime person, then there will be more tax complication, okay, in that. So then the review, the setup fee, okay, will vary, okay, based on that. So if you are interested to know more, do contact your, your estate planner or whoever that invite you to this session. Okay, I think I answered all the question. So if there's no more question, I would like to thank you for joining this sharing.
Thank you, everyone. Thank you, Jaclyn, for speaking today. If there's no other questions, we'll end off the session for today. So for the due to time constraints, we'll be ending the session now. If you have any other questions, do reach out to your estate planner who has invited you today, or for those who actually requested for a consultation, we'll get one of our estate planners to get in touch with you. Okay, thank you everyone for attending and for attention. Thank you. Bye-bye.